Let us learn about pregnancy discrimination and pregnancy-related disability discrimination. The Equal Employment Opportunity Commission, EEOC, enforces 3 federal laws that protect job applicants and employees who are pregnant. The first law is Title VII of the Civil Rights Act of 1964, as amended by the Pregnancy Discrimination Act, which is called Title VII. It prohibits sex discrimination, including pregnancy discrimination. Pregnancy discrimination under Title VII can be based on current pregnancy, past pregnancy, potential pregnancy, medical condition related to pregnancy or childbirth, including breastfeeding or lactation. The second law the EEOC enforces is the Pregnant Workers Fairness Act, which is called the PWFA. The PWFA requires a covered employer to provide a reasonable accommodation to a worker's known limitation related to pregnancy, childbirth, or related medical conditions, unless the accommodation will cause the employer an undue hardship. Under the PWFA, an employer must accommodate a worker's known limitation related to pregnancy, childbirth, or related medical conditions, except it constitutes an undue hardship. The PWFA also prohibits an employer from forcing a worker to take an accommodation, absent certain steps, and prohibits an employer from requiring a worker to take leave, if there is another accommodation that does not cause an undue hardship, that will allow the worker to stay on the job. The third law is the Americans with Disabilities Act, which is called the ADA. The ADA prohibits discrimination against an applicant or employee based on a disability, including a disability related to a pregnancy, such as diabetes, that may develop during pregnancy. While pregnancy itself is not a disability under the ADA, some pregnant workers may have one or more impairments related to their pregnancy that qualify as a disability under the ADA. An employer may have to provide that worker with a reasonable accommodation for the pregnancy-related disability. The ADA also requires that employers keep all medical records and information, including those that are pregnancy-related, confidential, and in separate medical files. Changes to the definition of the term disability, resulting from enactment of the ADA Amendments Act of 2008, make it much easier for pregnant workers with pregnancy-related impairments to demonstrate that they have disabilities for which they may be entitled to reasonable accommodation under the ADA. Reasonable accommodations available to pregnant workers with impairments that constitute disabilities might include allowing a pregnant worker to take more frequent breaks, to keep a water bottle at a workstation, or to use a stool, altering how job functions are performed, or providing a temporary assignment to a light-duty position. Now, let's talk about the Pregnancy Discrimination Act, PDA. Here are the fundamental Pregnancy Discrimination Act requirements. 1. An employer may not discriminate against an employee on the basis of pregnancy, childbirth, or related medical conditions, and 2. Women affected by pregnancy, childbirth, or related medical conditions must be treated the same as other persons not so affected, but similar in their ability or inability to work. An employer cannot refuse to hire a woman because of her pregnancy-related condition, as long as she is able to perform the major functions of her job. An employer cannot refuse to hire her because of its prejudices against pregnant workers, or because of the prejudices of co-workers, clients, or customers. The PDA also forbids discrimination based on pregnancy when it comes to any other aspect of employment. An employer may not single out pregnancy-related conditions for medical clearance procedures that are not required of employees who are similar in their ability or inability to work. For example, If an employer requires its employees to submit a doctor's statement concerning their inability to work before granting leave or paying sick benefits, the employer may require employees affected by pregnancy-related conditions to do the same, and vice versa. Pregnant employees must be permitted to work as long as they are able to perform their jobs. If an employee has been absent from work as a result of a pregnancy-related condition and recovers, her employer may not require her to remain on leave until the baby's birth. Nor may an employer have a rule that prohibits an employee from returning to work for a predetermined length of time after childbirth. Under the PDA, an employer that allows temporarily disabled employees to take disability leave or leave without pay must allow an employee who is temporarily disabled due to pregnancy to do the same. Employers must hold open a job for a pregnancy-related absence the same length of time that jobs are held open for employees on sick or temporary disability leave. Any health insurance provided by an employer must cover expenses for pregnancy-related conditions on the same basis as expenses for other medical conditions. The PDA specifies, however, that insurance coverage for expenses arising from abortion is not required, except where the life of the mother is endangered or medical complications arise from an abortion. Pregnancy-related expenses should be reimbursed in the same manner as those incurred for other medical conditions, whether payment is on a fixed basis or a percentage of reasonable and customary charge basis. The amounts payable by the insurance provider can be limited only to the same extent as costs for other conditions. No additional or larger deductible can be imposed. Under Title VII, benefits can be denied for medical costs arising from an existing pregnancy, if a health insurance plan excludes benefit payments for pre-existing conditions. Other laws, however, may apply to the coverage of pre-existing conditions. Employers must provide the same level of health benefits for spouses of male employees as they do for spouses of female employees. If an employer provides any benefits to workers on medical leave, the employer must provide the same benefits for those on medical leave for pregnancy-related conditions. Employees with pregnancy-related disabilities must be treated the same as other temporarily disabled employees for accrual and crediting of seniority, vacation calculation, pay increases, and temporary disability benefits. Pregnancy-related benefits cannot be limited to married employees. In an all-female workforce or job classification, benefits must be provided for pregnancy-related conditions, if benefits are provided for other medical conditions. If an employer provides any benefits to workers on leave, the employer must provide the same benefits for those on leave for pregnancy-related conditions. It is also unlawful to retaliate against an individual for opposing employment practices that discriminate based on pregnancy, or for filing a discrimination charge, testifying, or participating in any way in an investigation, proceeding, or litigation under Title VII. Violations have involved a variety of fact patterns, including refusing to hire, failing to promote, demoting, or firing pregnant workers after learning they are pregnant. Discharging workers who take medical leave for pregnancy-related conditions, such as a miscarriage. Limiting employment opportunities for pregnant women, such as by placing them on involuntary leave. Refusing to let them continue working beyond a certain point in the pregnancy, reducing work hours, or limiting work assignments due to employer safety concerns. Requiring medical clearances not required of non-pregnant workers. Failing to accommodate pregnancy-related work restrictions where similar accommodations are or would be provided to non-pregnant workers. Refusing to allow lactating mothers to return to work, and retaliating against employees, or those close to pregnant employees, who complained about pregnancy discrimination. Now, let's look at a couple of EEOC cases on pregnancy discrimination. EEOC vs. ACAL-SEC. Incorporated, 2010. The EEOC filed suit under Title VII alleging that ACAL, the largest provider of contract security services to the federal government, engaged in a nationwide pattern and practice of forcing its pregnant employees, working as contract security guards on U.S. Army bases, to take leave and discharging them because of pregnancy. EEOC vs. Houston Funding, 2013. In a precedent-setting decision, the U.S. Court of Appeals for the Fifth Circuit held that discharging a worker because she was lactating or expressing milk is illegal under Title VII's broad definition of sex discrimination, as well as under the specific terms of the Pregnancy Discrimination Act, added to Title VII in 1978. Lutovsky vs. Northwoods Nursing Center, 2013. When a nursing home learned one of its nursing assistants, Jennifer Lutovsky, was pregnant, it required her to provide a doctor's note stating she had no work restrictions. Ms. Lutovsky could not produce such a note, and the company later terminated her. EEOC vs. High Speed Enterprise Incorporated, doing business as Subway, 2011. The Commission sued this Phoenix area Subway franchise under Title VII, after it refused to hire Belinda Murillo. Ms. Murillo applied to work at the franchise, but the general manager admitted telling her, "We can't hire you because you're pregnant." EEOC vs. HCS Medical Staffing Incorporated, 2012. The Commission sued HCS Medical Staffing under Title VII to seek relief for Roxy Liga. With no prior warning or discipline, HCS terminated Ledger's employment and health insurance while she was still in the hospital, recovering from a cesarean section. EEOC vs. Step 3, Limited, 2013. The Commission sued Step 3 under Title VII and the Americans with Disabilities Act to seek relief for a female retail buyer who worked for the company in Honolulu. The employee informed the defendant that she had begun treatments for infertility. According to the Commission's suit, a company official responded with offensive comments regarding her disability. The EEOC alleged that later that year, when the employee revealed that she was pregnant and had related travel restrictions, the defendant fired her. Let's look at a question you may see in the HR certification exams. May an employer exclude a fertile female employee from certain jobs because of its concern for the health of the fetus the woman might conceive? An employer's concern about risks to the employee or her fetus will rarely, if ever, justify sex-specific job restrictions for a woman with childbearing capacity. This was determined in the UAW vs. Johnson Controls Incorporated case. This principle led the Supreme Court to conclude that a battery manufacturing company, Johnson Controls Incorporated, violated Title VII by broadly excluding all fertile women, but not similarly excluding fertile men, from jobs in which lead levels were defined as excessive, and which thereby potentially posed hazards to unborn children. The policy created a facial classification based on sex, according to the court, since it denied fertile women a choice given to fertile men, as to whether they wished to risk their reproductive health for a particular job. Accordingly, the policy could only be justified if the employer proved that female infertility was a bona fide occupational qualification, BFOQ. The court explained that decisions about the welfare of future children must be left to the parents, who conceive, bear, support, and raise them, rather than to the employers, who hire those parents. Now, let's look at a couple of scenarios. When Jermaine learned she was pregnant, she decided not to inform management at that time, because of concern that such an announcement would affect her chances of receiving a bonus at the upcoming anniversary of her employment. When she was 3 months pregnant, Jermaine's supervisor told her that she would not receive a bonus. Because the pregnancy was not obvious, and the evidence indicated that the decision-makers did not know of Jermaine's pregnancy at the time of the bonus decision, there is no reasonable cause to believe that Jermaine was subjected to pregnancy discrimination. 3 months after Maria told her supervisor that she was pregnant, she was absent several days due to an illness unrelated to her pregnancy. Soon after, pregnancy complications kept her out of the office for 2 additional days. When Maria returned to work, her supervisor said her body was trying to tell her something, and that he needed someone who would not have attendance problems. The following day, Maria was discharged. The investigation reveals that Maria's attendance record was comparable to, or better than, that of non-pregnant co-workers who remained employed. It is reasonable to conclude that her discharge was attributable to the supervisor's stereotypes about pregnant workers' attendance, rather than to Maria's actual attendance record and, therefore, was unlawful. We have over 30 resourceful membership videos to enable success in the HR certification exams. PHR, SPHR, SHRM-CP, SHRM-SCP. Be sure to join the membership of this channel. Click on the Join button today.